In our nation, the judiciary is the primary cornerstone of democracy, assisting in the efficient operation of democracy. Judges are the most visible members of the legal system. Judges must be efficient in order for the judiciary to be truly effective. The British ruled India for a period of almost 190 years. Yet, the English set up a poor copy of the British judicial system as Indian judicial system. Prior to the arrival of British, the local inhabitants of India had established their own system of judiciary. According to the traditions and customs of Hindu caste system, under the Panchayat system, the cases were decided. The Raja was the highest court of appeal. There were civil and criminal courts at local level. The judges were advised by the learned Brahmins as to the interpretation of Hindu law. The punishments were based on caste system. The Arabs entered into India in 712 AD. They introduced Qasi system for criminal cases in the areas of their influence while retained the old Panchayat system as to civil cases. The Mughals introduced Islamic judicial system. It was the mixture of Islamic, Persian and local Hindu systems. The first British Indian law code in Bengal, Bihar and Orissa was introduced during Hastings period. Two courts, which is the Faujdari Adalat and the Diwani Adalat, were introduced. The Faujdari Adalat dealt with criminal cases and the Diwani Adalat dealt with civil cases. Besides the Sadar Diwani Adalat, a court of appeal in civil cases, and the Sadar Nizamat Adalat as criminal cases appellate court were established in Calcutta. This system was in force up to 1793. The beginning of modern Indian public law appeared in 1833 with the creation of the Indian Law Commission, which in due time produced the Indian Penal Code and later the codes of criminal and civil procedure. Under the Charter of 1853, a new commission was appointed for the planning to create high courts in India on the lines of British judicial system and for the compilation of uniform code of law applicable to the whole judicial system, irrespective of religion and creed. Their recommendations were accepted, and in 1861, the Indian High Courts Act authorized the establishment of high courts in each of the following towns: Calcutta, Bombay and Madras. Under the Government of India Act 1935, the government abolished the old proportional arrangements of judges of high courts. The old rule of appointing the chief justices exclusively from among barristers or advocates was modified to the extent that they now might be appointed either from among the pleaders of the high courts or from among officers of the Indian Civil Service. Government of India Act 1935 provided for the creation of Federal Court, which was normally to be located at Delhi and was to consist of a Chief Justice and not more than 6 puisne judges. On 1st October 1937, the Federal Court was constituted. The Chief Justice and judges of Federal Court were to be appointed by the Crown. On August 15, 1947, India became independent from the British rule, and the Constitution of India was adopted on 26 November 1949, which came into force on 26 January 1950. One of the unique features of the Indian Constitution is that, notwithstanding the adoption of a federal system and existence of central acts and state acts in their respective spheres, it has generally provided for a single integrated system of courts to administer both union and state laws. At the apex of the entire judicial system exists the Supreme Court of India, below which are the high courts in each state or group of states. On the 28th of January 1950, 2 days after India became a sovereign democratic republic, the Supreme Court came into being. The original Constitution of 1950 envisaged a Supreme Court with a Chief Justice and 7 puisne judges, leaving it to Parliament to increase this number. As the work of the court increased and arrears of cases began to accumulate, Parliament increased the number of judges from 8 in 1950 to 34 in 2019. Qualification for appointment as a judge of Supreme Court. A person must be a citizen of India, must have been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or an advocate of a high court or of 2 or more such courts in succession for at least 10 years, or he must be, in the opinion of the President, a distinguished jurist. Provision exists for the appointment of a judge of a high court as an ad hoc judge of the Supreme Court, and for retired judges of the Supreme Court or high courts to sit and act as judges of that court. Whenever a vacancy is expected to arise in the office of a judge of the Supreme Court, the Chief Justice of India will initiate proposal and forward his recommendation to the Union Minister of Law, Justice and Company Affairs to fill up the vacancy. The opinion of the Chief Justice of India for appointment of a judge of the Supreme Court should be formed in consultation with the Collegium of the 4 senior-most puisne judges of the Supreme Court. The judges of the Supreme Court are appointed by the President under Article 124 of the Constitution. Until 1973, there existed a consensus between the government of the day and the Chief Justice of India. A convention was formed where the senior-most judge of the Supreme Court was to be appointed as the Chief Justice of India. In 1973, A.N. Ray was appointed as the Chief Justice of India. This violated the convention formed earlier, since Justice A.N. Ray superseded 3 other Supreme Court judges senior to him. Again, in 1977, another Chief Justice was appointed who superseded his seniors. This resulted in a clash between the executive and judiciary. A petition was filed in 1982 in the Supreme Court of India. This case is known as the S.P. Gupta case or First Judge's case. When asked the Supreme Court of India whether the word consultation in the constitutional Article 124 meant concurrence, the Supreme Court overruled this and denied, saying that consultation does not mean concurrence. The President was not bound to make a decision based on the consultation of the Supreme Court. Second Judge's case. Another petition was filed in 1993 by the Supreme Court Advocates on Record Association. In this case, the Supreme Court overruled its earlier verdict and changed the meaning of consultation to concurrence, thus binding the President of India with the consultation of the Chief Justice of India. This resulted in the birth of the Collegium system. Third Judge's case. In the year 1998, the presidential reference to the Supreme Court was issued questioning the meaning of the word consultation in Articles 124, 217 and 222 of the Constitution. The Chief Justice won't be the only one as a part of the consultation process. Consultation would include a collegium of 4 senior-most judges of the Supreme Court. Even if 2 of the judges are against the opinion, the CJI will not recommend it to the government. In the verdict, the Supreme Court laid down strict guidelines for the appointment of judges of the Supreme Court and High Courts, which is currently known as the Collegium system. In this system of appointment of judges, the Collegium will recommend the names of the candidates to the central government. Also, the central government will send the names of the proposed candidates for consultation. The appointment process takes a long time since there isn't a fixed time limit for it. If the Collegium resends the same name again, then the government has to give its assent to the names. The Collegium system faced a lot of criticism, not only from the government but also from civil societies due to its lack of transparency and accountability. This led to the 99th Constitutional Amendment Act 2014, the National Judicial Commission Act, to replace the Collegium system for the appointment of judges. The 1993 judgment was the basis on which a 5-judge constitution bench declared the National Judicial Appointments Commission Act and the 99th Constitutional Amendment Act 2014 unconstitutional in October 2015. NJAC too would recommend names for the appointment of Supreme Court judge and appointment and transfer of High Court judges. Composition of NJAC: the Chief Justice of India, 2 senior-most judges of the Supreme Court, the Law Minister of India, 2 eminent members that are chosen by the selection committee. However, the Supreme Court struck down the NJAC as unconstitutional in 2015, reaffirming the Collegium system. The criticism of Collegium system: unconstitutional and autocratic. Collegium is nowhere mentioned in the Constitution and has been evolved by the judiciary itself for retaining the power to select judges by itself. Undemocratic. Selection of judges by Collegium is undemocratic since judges are not elected by the people and are not accountable to the people or to anyone else. Opaqueness. No official procedure for selection. Nepotism. Sons and nephews of previous judges or senior lawyers tend to be popular choices for judicial roles. Thus, it encourages mediocrity in the judiciary by excluding talented ones. Inefficient. Collegium has not been able to prevent the increasing cases of vacancies of judges and cases in courts. To avoid the harnessing tussle between judiciary and executive, a transparent and viable collegium is needed. A written manual should be released by the Supreme Court, which should be followed during appointments, and records of all meetings should be in the public domain in order to ensure transparency and a rule-based process. There should be a degree of separation between the Judicial Appointments Commission and the court for a check and a corrective mechanism. Developing a permanent, independent body to institutionalize the process with adequate safeguards to preserve the judiciary's independence, guaranteeing judicial primacy but not judicial exclusivity. I'd like to conclude by quoting former Chief Justice of India, Praful Chandra Natwarlal Bhagwati. The court has to innovate new methods and strategies to provide access to justice to large masses of people who are denied basic human rights, to whom freedom and liberty have no meaning.